We've got ourselves a breaking news update in the Ripple versus SEC lawsuit. And it's actually pretty confusing, but the judge just gave an order. The reason I'm saying it's confusing is because a little bit of misinformation, or at least confusion, in posts was going around where Eleanor Tourette redid it. Now 30 minutes ago coming out with the latest version saying, okay, I'm going to redo this. Today, Judge Torres granted the SEC's request to file a motion to leave to file an interlocutory appeal in the Ripple case. They must file their request to leave to file by tomorrow, August 18th. Request to request. Law, huh? And so a little bit later in this video, you'll see what Ripple posted earlier today as, well, I was going to post a video about that, but then about 2 hours ago, this judge response came out and I was like, it was a little bit confusing everything. But before I move on, make sure you go ahead and press the like button on this video if you haven't done so already, as I'm trying to keep you up to date with all the most important Ripple, XRP, and whatever news. Anyway, to quickly dive in, Eleanor said Ripple's general counsel Stewart tells a show, "We're not afraid of an appeal. We think we would win on an appeal, but let's get there on an ordinary course. Let's stop bending the rules to accommodate the SEC's strategy of regulation by enforcement." And again, the piece that came out officially stated this: the court has set a briefing schedule for the SEC's request to file a motion for leave to file an interlocutory appeal. It is pretty confusing, I'm not going to lie. This does not mean an interlocutory appeal has been authorized. It just means the SEC is now allowed to request it. So what we were talking about before was the request to even, I guess, file a request. Oh, law can sometimes be so funny. So again, this does not even mean that their appeal has been granted. This just means that they can actually put it up and say, hey, now they're allowed to actually request an appeal. It's ridiculous, actually, that law works like this. Can I ask you a question to ask a question? That's kind of what this all feels like. Anyway, new dates. August 18th, so basically by tomorrow, or this now, I guess, the SEC's request to file a motion for leave to file an interlocutory appeal has been granted. Tomorrow/today, the SEC shall file their motion. By September 1st, the defendants, so Ripple and the guys, will file their opposition. And a week later, September 8th, the SEC shall file its reply. The parties are directed to comply with the deadline set forth unless something changes, but that is interesting. And again, just to answer some questions, another lawyer said, request to file motion for leave to file interlocutory appeal granted. Briefing schedule will be as requested by the SEC and unopposed by Ripple. But this doesn't mean the judge will necessarily grant it, right? And Fred said correct. It's kind of silly, really, because the upcoming motions are just going to be slightly longer versions of the letters that were just filed. But now we have time to pull up Judge Torres' statistics on granting and denying these. Anyway, even though this original response is now deleted because Eleanor made it even more confusing by saying, hey, this is it, and then redoing it, and now again a third time redoing it, John had this to say, though, even though, again, she deleted that part. As I said last week, she was going to grant the SEC the right to file a formal motion for the appeal. Now she can deny it and explain why she's denying it. So again, right now they officially are filing their appeal. Now she can deny it and explain why she's denying it, along with explaining why Rakoff is completely off. So again, to take a step back, because I like to always do that to make sure everybody understands everything, the way I perceive it is the SEC is not in the process of appealing it. Right now they are putting forth their appeal, and then the judge can say, okay, this can move forward and we're really going to rediscuss things, or no, you don't have the right, basically. And before, what we had was them requesting the right to even propose anything, so to speak. So there's like a little outer barrier that's not been broken, and now we're getting to the juicier parts, but not the juice of the juice. Because the juice of the juice we'd get the moment that this gets granted, and they can actually appeal. They can actually file an actual appeal. Anyway, now I'll say this all later in the video as I go over Ripple's response from earlier today. I'm going to include that because I already recorded that, like, let's see here, about 6-7 hours ago. But I didn't post it because I thought talking about the dump would be more important, as Bitcoin's price and the entire crypto market was moving down a lot. And I thought that would be a little bit more important to talk about. You can see people panicking a little bit, so I thought, hey. But that also meant I pushed this video out, and now we got ourselves an even juicier update. So I'm just combining the two by adding that entire video just right after this video. However, to come to the conclusion, it's still up for debate as to whether or not we think the appeal is nice or bad. If you think about it, the appeal can be good from the perspective that right then the judge can say, hey, this is what my opinion is on the matter, so Your appeal now has made me even more sure of it. So now it's also the same, I guess, way for all these other cases too. So it might have just helped out. On the opposite side, the moment that they do appeal, some things have to be rethought over. And if the judge isn't strong in her opinion, yeah, that would not be too nice then, I guess, to get that so quickly. It wouldn't change anything for XRP status, but still would be annoying. As I said last week, she was going to grant the SEC the right to file for a formal motion. Now she can deny it and explain why she's denying it, along with explaining why Rakoff, the other judge, is completely off regarding his understanding of what she ruled, because that's the judge in the Terra case. It was the SEC who categorized the different sales, not her. This should be fun, but it's going to take another 3 to 6 months for her ruling. So that means that these guys will file their appeals, or rather the idea that, hey, we want to appeal and this is our cause and our idea. But before she decides whether or not they should be allowed to appeal, it's going to be another couple of months, I guess. I didn't know it could take that long, which is peculiar because the SEC wanted to stop all the other things in the meantime. Fred said 3 to 6 months from today is November, February. The longer it takes, the better for Ripple. I think the ruling will be in October/November, just because this is a discretionary issue, mainly and not a legal one. I also recall Cherry Empress, an individual here, saying it took Judge Torres roughly a month to rule in the Rio Tinto intellectual appeal request, if I'm not mistaken. Anyway, sometimes I think that this is all just one big play, and the moment the decision is going to come is going to be at like either the best or the worst spot ever for XRP to kind of like mess up the prices even more. Just sometimes think about it like that. But at the end of the day here, guys, nothing to worry about, nothing too crazy. It's breaking news, I know, but it's not bad, not good. It's just a natural step forward. You might even say it is actually pretty good because now the judge can smash some things in the SEC's face, and before she really couldn't. And now we're going to add in, again, what I'll show you in just a second here, is Ripple's response from now almost yesterday, right? Where breaking news, Brad Garlinghouse and Chris Larsen filed their oppositions to the SEC's request to file an intellectual appeal and for a stay, which basically means to stop everything, of all proceedings pending appeal. So again, I'm going to talk about that now in the video I already previously recorded. So make sure you just, keep watching and make sure you go ahead and press the like button on this video. All right, we've got some very important news in the Ripple versus SEC lawsuit. Ripple responded, and I think you guys need to see what they said. So to start by giving you all the rundown, Ripple filed its opposition to the SEC's anticipated motion for leave to file an interlocutory appeal. If you do not know, Ripple was in basically a little bit of a tug of war with the SEC over XRP sales, XRP status, and a couple other parts. Now, the judge mostly ruled in favor of Ripple/XRP, naming XRP not a security, but naming some of Ripple's sales as investment contracts, yet on the opposite side, a lot of them not. And now the SEC is basically trying to say, for every sale that the judge deemed not an investment contract, we want to reverse that decision, or at least let's look over it again. Keep in mind that this is not about the status of XRP, as that's basically set in stone, as we'll see the CEO of Ripple explain. But if you guys enjoy these daily crypto videos, make sure you go ahead and press the like button on this video and let us dive right in. I like this part the most. For years, the SEC has pursued a strategy of regulating the US crypto industry through case-by-case enforcement. In keeping with that strategy, the SEC argued that the only question before the court was the application of the Howey test to the specific circumstances of this case. Having failed to meet its burden to present facts that would support stretching Howey to cover all of the defendant's distributions of digital asset XRP, the SEC now does an about-face, and rushes to appeal what it claims at one is a purely legal question, affecting all other digital asset cases. The court should reject this gambit because the SEC raised no such question at the start. The SEC can appeal the court's decision in the normal course after a final judgment with a full record. As again, this whole debacle here is not about whether or not the SEC's arguments for trying to reverse the decision is valid. The only thing they're looking into is it necessary for the appeal, because they're going to appeal anyway, for it to be now? Right now, today, basically, right? Because the SEC will most likely appeal anything they lost all the way after the case is over. And the only reason they shouldn't appeal, perhaps, is because then it gets set in stone, and they might not want that. They might want to keep this openness. On the contrary, with the way they've described things now, it seems they just want to try, because they've already, quote unquote, lost it anyway. Try get some sort of fell swoop in the Ripple case that they can use for all their other cases. By now trying to change the subject yet again, saying, no, it's purely a legal matter, even though they didn't state that before. Point being, this all, a lot of lawyers are describing as pretty damn good, as it's a very good explanation as to why they should not be allowed to file for it now. Again, their main points are, the court's order does not involve a controlling question of law, the SEC cannot show a substantial ground for difference of opinion, and an immediate appeal will not advance the termination of this litigation. Because again, those were all points that the SEC was making, and Ripple is saying things against that. Jeremy Hogan, a lawyer in the crypto space, saying, Ripple makes solid arguments why the appeal should not be allowed. But if it is allowed, Ripple is going to get its contractual obligations argument in front of the second district court, and that will be something. I'm talking amicus briefs raining from the heavens. Again, that being said, by contrast, defendants raised a legal question about the scope of the term investment contract as construed in Howey, and whether it can be applied where there's no contract between the buyer and seller that grants rights to the buyer and imposes obligations on the seller. If the SEC is permitted to appeal, defendants will seek to cross-appeal on this issue, as well as the factual bound portion of the court's order finding liability for certain transactions. We've got a couple of others stating their opinions, though. We've also got the CLO at Coinbase, basically the legal guy at Coinbase, the chief legal officer, saying powerful, especially in highlighting the hypocrisy of claiming a controlling issue of law, when they told the court precisely the opposite before, repeatedly even. And then he quotes a specific number here, see ECF number 837.6, whether or not a particular transaction involves the offer and sale of a security, will depend on the facts and circumstances. And at number 34, Howey must be applied to the facts and circumstances at hand. And it submitted more than 1,600 factual assertions that it claimed were relevant and material to the court's decision. I'm always amazed how lawyers and legals are able to find the specific pieces in all these different thousands of documents, basically. That's always something really interesting to me. However, the point here being that the SEC is yet again trying to change something mid-lawsuit. They've done this before, and the judge in the Ripple case did slap them down a little bit the moment that they tried. But it seems they're not done trying because, well, take a look at this again, huh? Wrath of Kahneman said this: Ripple argues the SEC appeal is a change in direction. Originally, the SEC claimed it was about Howey, not a matter of law, which Ripple actually tried to argue. Ripple says if Howey can appeal based on matters of law, Ripple will cross-appeal the whole thing. So Ripple would basically go for you try to stab me, but I'll stab you back twice, or something like that. John Dean basically also says, hey, this was an excellent response. The even stronger argument will be coming from next from Brad Garlinghouse and Chris Larson's attorneys related to the SEC's request for a stay. And the stay, as far as I understand it, being that they want to make sure the rest of the case is paused for a little while so they can figure this out. If it wasn't for the Rakoff ruling, I believe the Rakoff ruling has two parts. One is that this is, I believe, also Sam Bankman-Fried's lawyer. Not lawyer, sorry guys, the judge there who ruled for him to go to jail. I don't remember exactly though. But Rakoff, I believe, also was with the whole Terraform case where the guy said he did not agree with the Ripple SEC judge. So that cryptos basically are sometimes securities, sometimes, yeah. They basically said, no, whatever the judge said in the Ripple case, I don't care. All right, I don't agree. I will lean toward Judge Torres denying the SEC's request to file a motion for an intellectual appeal. The SEC doesn't even come close to meeting the standard justifying an early appeal because, again, this is not about the actual matters of law underneath. It's only about a matter of should they be allowed to appeal before the case is even over. So should this decision on the summary judgment be discussed again before the entire case is figured out? Usually no, unless you have some very good reason, and it seems now that the SEC does not have that. But with the Rakoff case ruling out there, her allowing the SEC to write a formal motion would give her an opportunity to further demonstrate why her decision is sound and based on evidence, or the lack thereof, thus making her decision even more appeal-proof. So what this is stating is perhaps the judge will actually allow for it because of some other judges that are disliking her ruling or disagreeing with hers, to basically set it more into stone that what she said is the baseline of things. The Ripple legal team said, "We oppose the SEC's request for an intellectual appeal. There's no extraordinary circumstances here that would justify departing from the rule, requiring all issues as to all parties to be resolved before an appeal." And Brad Garlinghouse said, "Reminder, the request for appeal, even if granted, doesn't change the fact that XRP is not a security. That's not up for debate or trial." But the SEC continues to claim that Chris and I acted recklessly in believing that XRP is not a security. That's utter nonsense. The judge's July 13 ruling said that the SEC would be put to their proofs at trial regarding their claim against Chris and me, and we look forward to proving the SEC wrong as a matter of fact and law again. And I'd say, guys, that all this brings up a very interesting piece, a very interesting question at that, and that is, what do we want right now with the whole SEC situation? Do we just want them to be cleared out of office, so every single one of these motherfrickers fired, new people in? Do you want the entity to be disbanded because they've not been functioning properly? Well, but they serve some purpose. In crypto, it's wrong, but in other instances, it might be okay the way they've been functioning. Do we want the judge to basically deny everything and let them suffer a little bit? Or do we want the judge to approve all of it, because that way the SEC is like double whammied here, right? Because that would mean that they can now not argue that, oh, we'll appeal in the future, because no, it's been shut down. And other cases and whatnot are also going to be more difficult because of this decision now. Like, every single one of these pieces has its advantages and disadvantages, to which I'd like to state, whatever the judge does will most likely be the best option. And honestly, I'm not really that worried that she's going to choose the wrong thing because of the way she wrote her initial statement. The way she wrote it, I'm thinking she was already pretty certain of her opinion on all these matters. And so the SEC, even trying to mess around basically and trying to get things to be redone, is not going to really change too much. Again, the whole issue as to whether or not XRP itself is security is not up for debate anymore. All we're talking about is how it was sold in some instances. But even that, the SEC is trying to throw around a little bit. They're trying to change the question at hand, etc., etc. But hey, can you expect anything else from the SEC? No, I never did. If you guys enjoy these videos, make sure you put that notification bell on so you're always up to date with whenever something crazy happens. And that's about it. See you guys again in another crypto video.